We hear a lot of people talk about breaking and entering. I was arrested for breaking and entering, convicted of breaking and entering. But the interesting thing is that here in California, there really is no distinct crime of breaking and entering. When people talk about that, usually they're referring to other crimes. And the two most common ones are burglary and vandalism. So burglary is when you enter a structure with the intent to commit theft or a felony inside. But you don't have to use forced entry. So for example, if somebody has their front door wide open and I walk through their front door into their house and steal something, that's burglary, even though I didn't use any sort of force to get in there. Now, vandalism is when you maliciously destroy or deface or damage somebody's property. So if I break a window or I pick a lock trying to get in and that damages their property, I could be charged with vandalism. But vandalism does not require that I enter the structure. So maybe I try to pick the lock and I damage it, but I get nervous and I run off. I never actually enter the home. I can still be charged with vandalism. So in that sense, burglary can be entering without breaking, and vandalism can be breaking without entering. But when we hear people talk about breaking and entering as a crime, it's really not a separate crime. It's usually sort of an umbrella term that's used to refer to burglary or vandalism or one of these related crimes.